further questions, Your Honor.
Counselor, your witness.
Thank you, Your Honor. Mr. Morrison, you just told your attorney on direct examination that when you first saw the traffic light at the intersection where the accident occurred, the light was green when you first saw it, and then it proceeded to turn yellow as you went through the intersection. Do you remember that?
Yes.
Well, sir, do you remember giving a deposition in this case in my office approximately 8 months ago?
Yes, I remember.
And do you remember being asked the following questions and giving the following answers? Mr. Morrison, what color was the traffic light when you first saw it? And what color was the light when you proceeded through the intersection? And you answered, well, the light had just turned to yellow when I first saw it, and when I went through the intersection, it turned to red. Do you recall being asked that question at your deposition and giving that answer?
Yes, I remember.
Well, sir, you just testified that the light was green when you first saw it, and it turned to yellow as you went through the intersection on direct examination. Do you remember that?
Yes.
Well, sir, you just told your attorney on direct examination that the light was green when you first saw it, and then had changed to yellow as you went through the intersection. And 8 months ago at your deposition, you testified that the light was yellow when you first saw it, and then changed to red as you proceeded through the intersection. Do you remember that?
Yes, I remember.
Well, the light could only be yellow when you first saw it, or green when you first saw it, correct?
Correct.
Mr. Morrison, did you take an oath to tell the truth before you took the witness stand this afternoon?
Yes, I did.
And you took an oath to tell the truth at your deposition 8 months ago in my office, correct?
Correct.
So, sir, what I'm asking you here today is, what version of the story is the truth? The version of the story that you gave 8 months ago in your deposition, or the version of the story that you're giving us here today in court?
I don't know.
Well, sir, if that light was red as you proceeded through the intersection, isn't it possible that the light was green for the plaintiff as he proceeded through the intersection?
Yes, it's possible. It's possible.
Nothing further, Your Honor. Hello, my name is Glenn Curtis. I'm a New York licensed attorney practicing in the areas of commercial law and personal injury litigation. I developed this video to help you understand and become comfortable with the next phase of your case, the deposition. By the end of this video, you'll have a clear understanding of what a deposition is, how important it is, and what to do when faced with particular situations during the actual deposition. You just saw how critical the deposition can be during the course of a trial, but it's also an important fact-gathering tool, not only for your opponent, but for your attorney as well. It's rare that I don't find out a few facts about my client, their case, or the opponent during the course of the deposition that I didn't already otherwise know. So let's take a look and see how those all-important questions and answers came about. First, what is a deposition? A deposition, or sometimes called an EBT, short for examination before trial, is when the adversary or opposing attorney has the opportunity to ask questions of a witness or party in a legal action. The questions and answers are on the record or recorded by a certified court stenographer. The attorneys in the case are then given copies of the transcript of the deposition to help them understand the facts of the case, to prepare for the trial, and as you saw earlier, to cross-examine a witness on the witness stand. The length of the deposition can last anywhere from half an hour or less to literally days in complex cases. By the phase of the case where you're preparing and appearing for your deposition, your attorney and the opposing attorney or adversary have probably met several times in court and spoken on the telephone numerous times. It's fair to say that the attorneys have developed some sort of relationship, whether purely adversarial or friendly and courteous. The deposition will most likely be your first and only chance to meet and be in contact with the adversary prior to trial. It will serve not only as a tool to evaluate your case, but to evaluate you as well, your demeanor, your type of personality, and your knowledge of the facts that led up to the action being filed, and of as your attorney as an advocate. It will also be used by the other side to try to determine what type of witness you'll be on the witness stand, should the case go to trial. You may come across as strong, weak, evasive, candid, etc. The deposition is also an important factor in resolving your case for those reasons. Let me identify the likely players who will be involved in your deposition. The stenographer or court reporter. He or she will be there not only to record what is said, but also to read questions and responses back to the parties where they were not heard or understood, and to mark exhibits that might be used during the questioning. We'll take a look at both of those instances a little later. A few weeks after the deposition is over, you'll receive a copy of the transcript from your attorney. You'll have the opportunity to make corrections in the transcript that the stenographer may have transcribed incorrectly. The adversary or opposing attorney will be there. That's the attorney who will be asking the questions. Almost everything said to a witness by the adversary will be done on the record and recorded by the stenographer. It's generally not proper for an adversary to speak to a party in the action without their lawyer present. So don't feel that the attorney is being rude by merely saying hello and doesn't engage in small talk while you're waiting for the other parties to arrive. Your attorney will be present. They'll discuss the deposition further with you and prepare you for specific types of questions that may be asked by the adversary. They will also make objections to improper questions and advise you on what to do. We'll take a look at this a little later as well. You, the witness, of course, will also be there. Remember, not only will a deposition be used to evaluate the facts of the case, but also you as a witness. Your dress should be at least business casual. There's no specific need to wear a suit and tie, but bear in mind you might be sitting for a few hours, so keep your own comfort in mind. There are also subtle elements that the adversary may use to evaluate